Good morning. I hereby call to order this first meeting of the Pennsylvania Public Utility Commission for the year 2020, and I ask that you please stand for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. We are definitely in a new year. We've got the flags in the right position this time. We're good to go. As always, I ask that you please note the safety information on the inside of the cover of your agenda, and also know that the Commission will act on various matters at today's meeting, which is open to the public. However, since adequate forums have been made available for public participation in cases before this Commission, there is no opportunity for the public to address the Commission at this public meeting. So our first matter for this morning's agenda is the approval of the minutes for December 5th, 2019, and I call on Commissioner Place, who is the editor.
Thank you very much. I've reviewed the minutes of the December 5th, 2019 public meeting and move that they be approved as submitted.
You have heard the motion for the approval of the minutes. Is there a second?
Second.
Second by Commissioner Unora. Any discussion on the motion or further edits? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0. Now we will move on to this morning's agenda, calling upon our Secretary, Rosemary Chiavetta, to lead us through the agenda.
Good morning, Madam Chairman. Good morning, Commissioners, and Happy New Year.
Good morning. Happy New Year.
Your various bureaus and offices have prepared the following agenda items for your consideration. Therefore, let us begin on page 1. It is recommended by Director Monahan and the Bureau of Audits that the Commission release the audit report of Columbia Gas of Pennsylvania to the public.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Place, second by Commissioner Coleman. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Turning to page 2, in matters presented by Director Bechtel in the Bureau of Consumer Services. Madam Chairman, it should be noted for the record that the first item, the USEP plan for Columbia Gas, contains a typo, and the revised plan should read 2019 through 2023 and not 2021. With that correction made, it is recommended in an omnibus motion that the Commission adopt the 2019 through 2023 USEP order of Columbia Gas of Pennsylvania and the 2020 through 2025 USEP plan of UGI Utilities.
Is there a motion to adopt staff recommendations?
So moved.
Is there a second?
Second.
Motion by Commissioner Unora, second by Commissioner Place. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Turning to page 3, and matters presented by Director Sophie and the Office of Special Assistants. It is recommended in an omnibus motion that the Commission adopt both items on page 3, beginning with the complaint of Orpheus and Kimberly Hanley versus the Pennsylvania Power Company, and continuing to include both items on page 4, ending with the complaint of Thomas Aguirre versus PPL Electric Utilities.
Is there a motion to adopt the staff recommendations?
So moved.
Is there a second?
Second.
Motion by Commissioner Coleman, second by Vice Chairman Sweet. Any discussion on the motions or any discussion on the motion? All those in favor say aye.
Aye.
Any opposed? The matter passes 5-0.
Turning to page 5, it is recommended that the Commission adopt the proposed opinion and order in the joint application of Aqua and Peoples Gas.
Is there a motion to adopt staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Unora, second by Commissioner Coleman. Any discussion?
Madam Chair, I have a motion.
Vice Chairman Sweet.
Thank you. Before the Commission, the joint applications of Aqua America, Inc., its subsidiaries, and the Peoples Natural Gas Company seeking approval for Aqua America, Inc. to purchase all of the issued and outstanding membership interests in LDC Funding, which owns the PNG Companies, LLC, which in turn owns the Peoples Natural Gas Company, Peoples, formerly TWP, and the Equitable Division. Along with the certificated companies are a number of non-jurisdictional entities which will also transfer to Aqua America. This transaction's received a thorough vetting in a sometimes contentious proceeding before this commission, and the result is a non-unanimous settlement of all issues. Notwithstanding the very real concerns expressed by the Office of Small Business Advocate and the Commission's Bureau of Investigation and Enforcement, I believe that the public interest is best served by approving the joint petition for non-unanimous settlement with just a few modifications. In addition to the buyer and the seller, I would note that the non-unanimous settlement was joined by the Office of Consumer Advocate, Cause PA, Direct Energy, the NGS parties, PIOGA, and two labor groups, UW, UA Local 612, and the Laborers District Council in Western Pennsylvania. Regarding the costs for the Goodwin and Tombaugh gathering system upgrade, the joint petition states in paragraph 33 that this recovery is approved by the signatories for up to $120 million in a base rate case, and not through People's Distribution System Improvement Charge, DISC. As a modification here and a clarification, I move that the Commission interpret this section to mean that the $120 million for rehabilitation of the bare steel in the system is eligible for full recovery, subject to Commission scrutiny and approval in a subsequent base rate proceeding, and is not a guaranteed capital recovery. In addition, the timing of the rate credit of $13 million must be adjusted to recognize that the deadline set therein has passed, and a new deadline must be established. As these two factors are a modification of the joint petition for non-unanimous settlement, they should be noted in the ordering paragraphs of the Commission's opinion and order, along with acknowledging an opportunity for the parties to withdraw from the settlement if these changes are not acceptable to that party. Therefore, I move that number one, that the exceptions filed by the Office of Business Advocate and the Bureau of Investigation and Enforcement are denied, consistent with this motion. Secondly, that the recommended decision of Administrative Law Judge Mary D. Long approving the non-unanimous settlement petition is adopted as modified by the changes listed below. Number three, paragraph 41 of the settlement agreement is modified to accommodate the fact that the date stated therein has already passed, and by setting a new reasonable date. Number four, that paragraph 33 is interpreted to mean that $120 million for rehabilitation of the bare steel in the Goodwin and Tombaugh gathering systems is eligible for full recovery, subject to the scrutiny and Commission approval of a base rate case, and is not a guaranteed sum. It's not a blank check. Number five, that any party wishing to withdraw from the settlement agreement shall file with the Secretary of the Commission and serve on all parties to this proceeding an election to withdraw within 5 days from the date of the Commission's opinion and order. If such an election to withdraw is filed, the settlement agreement shall be void and of no effect under its own terms in paragraph 129, and this matter shall be returned to the Commission's Office of Administrative Law Judge for further action as deemed to be appropriate. And finally, that the Office of Special Assistance prepare an appropriate opinion and order consistent with this motion, which also directs the specific actions agreed to in the non-unanimous settlement. Thank you.
Thank you, Vice Chairman Sweet. You have heard the motion of Vice Chairman Sweet. Is there a second to the motion?
Second.
Second by Commissioner Coleman. Any discussion on the motion?
I have a statement on the matter.
Commissioner Place.
Thank you. Well, I support the aspects of the motion of my colleague as to the proper application of the rate-making principles applicable to recovery of capital costs. I must respectfully vote no on the motion, as I do not believe the merger application, as amended by the non-unanimous settlement, constitutes an affirmative public benefit. Thank you.
Thank you, Commissioner Place. I do have a verbal statement on your motion. I just want to say, I want to thank you for the clarifications in your motion. I really do appreciate them and concur with them. Any further comments and discussion on the motion? Hearing none. All those in favor say aye.
Aye.
Any opposed?
Opposed?
The motion passes 4-1, noting the dissent of Commissioner Place. On the matter as amended, are there any comments?
I have a statement on the matter.
Commissioner Place.
Thank you very much. Madam Secretary, I would like to have my statement placed in the record as if I had read it in its entirety. Before us is noted for consideration and disposition as the recommended decision of Administrative Law Judge Mary D. Long and the relevant exceptions and reply exceptions that have been submitted by various participating parties. This matter concerns the acquisition and transfer of control of Peoples Natural Gas Company, LLC, Peoples Natural Gas Company, LLC Equitable Division, and Peoples Gas Company, LLC by Aqua America Incorporated, the parent corporation of Aqua Pennsylvania Incorporated, and Aqua Pennsylvania Wastewater Incorporated. ALJ Long's RD has recommended the approval of a non-unanimous settlement petition that has been put forward by the joint applicants and most of the participating parties in the proceeding. This non-unanimous settlement is opposed by the Commission's Bureau of Investigation and Enforcement and the Office of Small Business Advocate, as noted. I do not believe that this acquisition and the accompanying parameters of the non-unanimous settlement provide the substantive net affirmative benefits that are required by statutory law and applicable legal precedent. The proposed transaction also includes a substantial goodwill or acquisition premium in the approximate amount of $2 billion. The non-unanimous settlement terms have attempted to ring-fence the Pennsylvania regulated operations of Aqua PA and the Peoples Companies from the potential effects of this goodwill acquisition premium. However, goodwill acquisition premiums of such magnitude possess their own and often unpredictable dynamics. Consequently, I believe that the proposed transaction is not in the public interest and should not be approved for the following reasons that are further detailed in my written statement. The joint applicants have not demonstrated any quantifiable cost savings that result from the proposed transaction. Merger synergies are not part of the affirmative net public benefits. The one-time $10 million rate credit for the consumers of Aqua PA and the Peoples Companies is eclipsed by the negative effects and the financial risks associated with the proposed transaction. The goodwill acquisition premium of $2 billion, which is more than 80% in excess of the base purchase price of $2.275 billion, presents the most serious challenge to the future viability of the proposed transaction and the financial stability of Aqua America. The ring-fencing financial safeguards in the non-unanimous settlement are not absolute and they are not comprehensive. Credible testimony on the record indicates a potential impairment of the goodwill premium at the present level that will have negative financial implications both for Aqua America and for the regulated operations of Aqua PA and Peoples in Pennsylvania. The non-unanimous settlement contains provisions for maintaining or improving various utility services. However, these provisions lack any penalties for non-performance and thus appear ineffective in practice. I have serious concerns regarding the proposed rehabilitation of the Goodwin-Tombaugh gathering system. Full pipeline replacement will result in an estimated net present value cost to ratepayers of $91.7 million before the one-time $13 million rate credit. Furthermore, these cost estimates are based on a replacement cost that may be significantly understated. There currently is a methodology in place for addressing the G&T system issues from a prior 2013 settlement agreement, as noted. Consequently, the G&T system issues should have been addressed in a separate proceeding and not as part of the presently proposed transaction. The continuation of the status quo, the structural separation of the Aqua PA and Peoples regulated operations, and the provision of services to the public in accordance with the provisions of the Public Utility Code and this Commission's regulations do not constitute affirmative net public benefits and cannot be labeled as such. The argument that the Peoples Company's reversion to public ownership constitutes an affirmative net public benefit holds no merit. The regulated public utility subsidiaries of Aqua America and Pennsylvania are not and will not be publicly traded companies in the first place. These regulated public utilities are already under the regulatory oversight of the Commission and associated reporting obligations. The contemplated acceleration of People's long-term infrastructure improvement plan will be compensated by the ratepayers of its regulated operations. Such acceleration can hardly be named as an affirmative net public benefit, as this acceleration can be achieved without any merger agreement. Other provisions of the non-unanimous settlement mostly seek to ameliorate potential negative impacts of the merger. However, in aggregate, the ameliorants do not offset the costs. For the above referenced reasons, I do not favor the approval of the proposed transaction and the non-unanimous settlement that is before us today. Thank you.
Thank you, Commissioner Place. Any further discussion? I do have comments I would like to place on the record in their entirety, but I will actually read them also in their entirety. So before the Commission are exceptions to the recommended decision approving the non-unanimous settlement for the proposed acquisition of the People's Company by Aqua America. While overall I believe this transaction is in the public interest and warrants approval, I wish to address my concerns with the provisions related to the Goodwin and Tomball gathering systems. I do appreciate the motion that was approved by Vice Chairman Sweet, but I still would like to address some concerns. These two gathering line systems were included in the prior transfer of the People's Company from EQT approved in 2013. At that time, the Commission approved a full settlement, which included directives for action on these two gathering systems. The Goodwin and Tomball gathering systems total approximately 379 miles of natural gas gathering pipeline and associated facilities in Greene and Washington counties owned by PNG. PNG Gathering, a non-utility affiliate of the People's Company. There are approximately 1,602 end-use gas customers served from these lines. In the 2013 settlement, it included $5 million for the purpose of investigating the condition of the systems, repairing leaks, and preparing an assessment. The 2013 settlement directs that after completion of the assessment, Peoples and PNG Gathering would meet with the public advocates, including the Commission's Gas Safety Division, to discuss options and to present a plan to the Commission. Periodic updates have been filed in that docket, and the last report indicates that Peoples is now ready to discuss the matter with the public advocates and to develop a plan to file with the Commission. Given this background, the disposition presented at this docket on how to manage the Goodwin and Tomball gathering systems appears premature and lacks the full evidentiary record that I would prefer for such a substantial proposal. Here, Aqua America and the People's Companies would be permitted to potentially recover up to $120 million in costs related to the rehabilitation of these gathering systems. When accounting for the proposed one-time $13 million credit, the avoided cost of abandonment, and the net present value of revenues from this investment, ratepayers will be on the hook for approximately $79 million. This equates to the cost of approximately $43,000 per customer to rehabilitate the Goodwin and Tomball gathering systems. While on its face this cost seems high, I understand this is a tough predicament. Both systems leak significant amounts of gas, with the record here indicating lost and unaccounted gas numbers of 82% and 44% for Goodwin and Tomball, respectively. As such, rehabilitating these systems will have a substantial environmental benefit and should reduce the potential of a catastrophic natural gas explosion. Nonetheless, I am sympathetic to the Office of Small Business Advocates' position that the rehabilitation of these gathering systems would be best handled in the docket commenced pursuant to the 2013 settlement. The Commission has already provided this vehicle and directives regarding these lines, and under that earlier docket, a methodology is set forth. Packaging the completion of the 2013 settlement into the instant proceeding appears to unnecessarily truncate the analysis of a very complex issue, A preferable solution would have been for the parties to concentrate solely on the gathering lines in order to develop a thorough and complete evidentiary record regarding their disposition. Noting my concern with this sole issue, I acknowledge that the proposed settlement is designed in a manner which offers numerous public benefits. While not an exhaustive list, I wish to highlight some of these. First, the record states that the proposed transaction will be accretive to Aqua America's earnings. As well, approval of the non-unanimous settlement will allow the People's Company to gain access to public equity. The settlement also states that expenses for goodwill, transaction costs, transition costs, and the cost of equity or debt issued to finance goodwill will not be recovered by the People's Companies or Aqua America's rates. Moving on, the People's Companies commit to amend their existing long-term infrastructure improvement plan, or LTIP, to allow for the additional replacement of 25 miles of at-risk pipe per year. The settlement also includes a commitment to integrate an enterprise-wide management information system leveraging the experience of the People's Company. Finally, Aqua America commits to providing a one-time $10 million rate credit to the People's Companies and Aqua America customers. I commend the parties in the proceeding for reaching these terms. In totality, these benefits outweigh my concerns related to the gathering systems. Therefore, I will vote in support of the matter as amended to approve the acquisition. If there are no further comments on the matter as amended, all those in favor say aye.
Aye.
Any opposed?
Opposed.
The motion passes 4-1, noting the dissent of Commissioner Place.
Finally, at the bottom of page 5, it is recommended that the commission adopt the proposed opinion and order in the joint petition of Verizon North and Delta Telecom.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Place, second by Commissioner Coleman. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Turning to page 6, in matters presented by Director Diskin and the Bureau of Technical Utility Services, it is recommended in an omnibus motion that the commission adopt both items on page 6, beginning with the tentative order regarding EGS license cancellations, and continuing the omnibus to include both items on page 7, all of the items on page 8, all of the items on page 9, and both items on page 10, ending with the security certificate of Columbia Gas of Pennsylvania.
Is there a motion to adopt the staff recommendations?
So moved.
Is there a second?
Second.
Motion by Commissioner Coleman, second by Vice Chairman Sweet. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Turning to page 11, it is recommended that the commission adopt the proposed order regarding the letter of notification filed by Mid-Atlantic Interstate Transmission.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Sweet, second by Commissioner Yunora. Any discussion?
So, a statement on the matter?
Commissioner Place.
Thank you. Madam Secretary, I ask that my statement be placed in the record as if I had read it in its entirety. Before the Pennsylvania Public Utility Commission for consideration and disposition is the letter of notification for approval of the Mid-Atlantic Interstate Transmission LLC to realign structures on the 967 Smith Street, Westgate, York Solid Waste 115 kV transmission line in Manchester Township, York County, Pennsylvania. I support the approval of this law. However, with that said, MAIT has provided very limited information on the $1.1 million cost estimate for removing one existing transmission structure and installing two new transmission structures, all within the existing right-of-way. The project is needed to accommodate construction of a Pennsylvania Department of Transportation maintenance facility driveway. Given what appears to be minor construction activity, I would ask that MAIT exercise due diligence to minimize these costs charged to PennDOT. Though transmission customers of MAIT, and by extension the ratepayers of Pennsylvania, are not responsible for these costs, all citizens of the Commonwealth bear the burden of the transmission cost, construction costs, in this case, as PennDOT will reimburse MAIT for the project. Thank you.
Thank you, Commissioner Place. Any further discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Turning to page 12, in matters presented by Chief A.L.J. Rainey in the Office of Administrative Law Judge, it is recommended that the Commission adopt A.L.J. Long's initial decision in the complaint of Shirley and Jeffrey Porro versus the Pittsburgh Water and Sewer Authority.
Is there a motion to adopt staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Place, second by Commissioner Unora. Under discussion, I do have a motion, so I would ask that Vice Chairman Sweet would preside.
Thank you, Madam Chair, and you're recognized for the purposes of offering your motion.
Thank you. I ask that my motion be spread upon the record as if I read it in its entirety. Before the Commission is the formal complaint of Shirley and Jeffrey Porro versus Pittsburgh Water and Sewer Authority. In their complaint, the Porros contend PWSA failed to properly maintain storm sewers in Phillips Park, located near their home, which caused damage to the retaining walls on their property. As relief, the complainants asked that the sewers be cleaned out routinely and that there be additional sewers added to Phillips Park. The presiding administrative law judge dismissed the complaint, concluding that PWSA did not violate the code by failing to provide reasonable stormwater facilities. I must respectfully disagree. It is clear that PWSA is responsible for the maintenance of the catch basins at Phillips Park. Review of the record shows that these catch basins were filled with debris during the days preceding May 16, 2018. The complainants contacted the city of Pittsburgh at that time to inform it of the blocked basins. In response, PWSA attempted to access the park to remedy the situation, but the access road was in poor condition and could not be traversed by the requiring cleaning trucks. On May 16, 2018, heavy rain caused the Porros property to be flooded. This resulted in the washout of the complainant's retaining wall. The overflow of the water appears to be the direct result of the backed up catch basins. The complainants contacted PWSA again after this event. On May 30, 2018, PWSA again arrived at Phillips Park, and again could not gain access to the catch basins they have to unclog. I acknowledge that the Commission is presently working to develop standards of service for PWSA's stormwater collection operations. However, in the absence of any specific standards, this Commission is guided by the requirements of Section 1501 of the Code. That section mandates that a public utility must furnish and maintain adequate, efficient, safe, and reasonable service facilities. This complaint involves an issue of first impression, given the Commission's relatively new jurisdiction over PWSA, and to a greater degree, our jurisdiction of PWSA's stormwater operation. In this instance, I find that PWSA's inability to access its facilities for the purposes of repair to be in violation of Section 1501, requirement to maintain adequate and reasonable service. The record shows that the City of Pittsburgh's Public Works Department was responsible for management of the park's access road. However, regardless of these circumstances, it is incumbent on regulated utilities to operate in a manner which permits access to their facilities for the purposes of maintaining reasonable service. To that end, I believe the record here substantiates the granting of the Porros complaint insofar as it seeks to have the authority clean out the catch basins on a routine basis. However, insofar as the complainant seeks a remedy mandating that the authority install additional sewers at Phillips Park, I do not believe there is sufficient evidence on the record to grant such action. I find that the inaction of PWSA does not appear to be repetitive or of significantly high consequence, since the issue here only reflects damage to one customer's property. Further, I note the record evidence states that PWSA has now committed a good faith to inspect and clean the catch basins once every 3 months, satisfying the first remedy sought by the Porros. I would also be remiss to not to acknowledge that the authority is still working to transition to an operational position that fully complies with the Public Utility Code. I understand this is no small feat, and therefore I am cognizant that there may be scenarios and instances in front of the Commission that are transitory in nature. Consequently, I believe it is unnecessary to level a civil penalty in this proceeding. It is my hope that this issue of first impression and the disposition I propose herein can be utilized by PWSA to provide a greater understanding of the Commission's reasonable service expectations moving forward. Therefore, I move that 1, the initial decision be modified consistent with this motion, and 2, the Office of Special Assistance draft an opinion and order consistent with this motion.
Thank you, Madam Chair. Is there a second?
Second?
It has been moved and seconded. Is there any further discussion? Seeing none, I will call the vote. All those in favor signify by saying aye.
Aye.
Aye. Opposed? The motion is adopted 5-0. Without objection, we will take the final roll call as the same, 5-0. Seeing no objection, that is the case. I'll turn the gavel back over to you.
Thank you very much.
It is recommended that the Commission adopt ALJ Barnes's initial decision in the complaint of Anthony Vanini versus PPL Electric Utilities.
Is there a motion to adopt staff recommendation?
So moved?
Is there a second?
Second.
Motion by Commissioner Place, second by Commissioner Unora. Any discussion?
I have a motion, Madam Chair. Actually, we have a motion.
Vice Chairman Place. Sweet.
Thank you.
I'm gonna get it right.
Excuse me. Before the Commission is the initial decision ID of the Administrative Law Judge Elizabeth H. Barnes, the ALJ, which grants a motion to dismiss the complaint because the complainant, Anthony Vanini, failed to comply with 2 of her orders. An order granting a motion to compel Mr. Vanini to serve full and complete responses to the respondent PP&L Electric Utilities Corporation's discovery, and the ALJ's second pre-hearing order, which directed Mr. Vanini to provide a list of witnesses and any expert witnesses' written testimony or exhibits by a date certain. Mr. Vanini's complaint has 2 counts. First, he objects to PP&L's plans to install a smart meter at his residence, and secondly, he alleges that his bills were incorrect. He states that he is a low-income customer and seeks reimbursement for the errors. We agree with the ALJ that the failure of any party to comply with orders of the Commission or an order of the Commission or an administrative law judge provides ample grounds for sanctions. There are numerous Commission dockets in which sanctions are appropriately applied for such failure. The sanctions will vary depending upon the nature of the action or omission. In smart meter cases, for example, it is crucial to the fair conduct of the litigation that the parties exchange witness lists in advance. They must be given an opportunity to prepare their own cases by reviewing what the other side will offer at the hearing. When one side fails to provide this information, the other side's ability to prepare for the case is unfairly restricted. That is why the appropriate sanction, after several warnings to the offending party, is to dismiss the complaint. A complex litigated proceeding must be held to a high standard. However, the Commission does not dismiss high billing complaints for failure to respond to discovery or provide a witness list in advance. In fact, rarely is there a justification for serving discovery on a self-represented complainant in a high billing case. While we cannot say that it would never be justified to dismiss a high billing complaint for a customer's failure to respond to discovery, it would need to be under very specific circumstances. We believe that this customer's high billing complaint should be set for hearing, although the smart meter portion of the complaint will be barred for failure to comply with the ALJ's orders. Therefore, we move that the initial decision of the ALJ is affirmed insofar as it grants the motion to dismiss the smart meter count of the underlying complaint and reversed insofar as it grants the motion to dismiss the high billing count of the underlying complaint. Secondly, that the high billing count is remanded to the Office of Administrative Law Judge for further proceedings as appropriate. And finally, the Office of Special Assistance is to prepare an appropriate order consistent with this motion. Thank you.
Thank you. You have heard the joint motion as read by Vice Chairman Sweet. Is there a second?
Second?
Second by Commissioner Place. Any discussion on the motion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0. If there's no objection, we'll take the previous roll call. On the matter as amended, the motion passes 5-0.
Madam Chairman, that concludes regular agenda. Turning now to the carry-in agenda. On page 1 of the carry-in, it is recommended by the Office of Special Assistance that the Commission adopt the proposed opinion and order in the formal complaint and petition for reconsideration of Nelson Hess versus PPL Electric Utilities.
Is there a motion to adopt the staff recommendation?
So moved?
Is there a second?
Second.
Motion by Commissioner Place. I think I heard Commissioner Coleman or Vice Chairman.
You mistook my voice for anybody?
Second by Vice Chairman Sweet. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? Motion passes 5-0.
Turning to page 2 of the carry-in, it is recommended by the Law Bureau that the Commission adopt the proposed order in the petition of Velocity.net Communications.
Is there a motion to adopt the staff recommendation?
So moved?
Is there a second?
Second. Third.
I did hear Commissioner Coleman the first time. That's right.
That was me.
Okay, that was it. And second, I heard Vice Chairman Sweet. He was louder, unfortunately. Right? We'll get this right. All those in favor say aye.
Aye.
Any opposed? Motion passes 5-0.
Madam Chairman and Commissioners, that concludes all agenda items to be considered today.
Thank you very much. Before we adjourn, let me just say that we will have a retirement announcement afterwards, so I please ask that you stay in your seats or stay behind if you can for that. Is there a motion to adjourn?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Sweet, second by Commissioner Coleman. I believe there's probably no discussion on an adjournment, right? All those in favor say aye.
Aye.
Any opposed? We are adjourned.